is Wednesday, October 16, and we set up a work session of the Lane County Board of Commissioners today on potential referral of an aerial spray measure, an ordinance, and potential individual commissioner liability for a referral. We've set up this work session in a fairly rigorous fashion. We allocated 15 minutes to Mr. Dan Meek, the attorney representing the proponents of the measure. Following him, we will have a time split between Mr. Gregory Chamoff, who represents the Oregon Farm Bureau, and Mr. William Gary, who represents Stan Long. They will divide 15 minutes. Following that, we will have Steve Dingle make a presentation up to 5 minutes. Then we'll have a question and answer period where the commissioners will ask questions of the 4 people involved. And following that, we will have a summary period of Mr. Meek taking 3 minutes, Mr. Chamoff and Mr. Gary dividing 3 minutes, and Mr. Dingle taking 3 minutes. And we expect to be out of the room in approximately 2¼ hours. So the city of Eugene has the room, and we have to be out of here near that time for the television crew to set up. Before I call on Mr. Meek, who I know is on the telephone, I'd like to ask Mr. Dingle if that accurately reflects everything that folks have been told.
It does, Mr. Chair, and it's actually set out on the agenda, and I sent out an email 6 or 7 weeks ago.
Okay, very good. So, Mr. Meek, I'm going to ask our Vice Chair, Commissioner Buck, to set the timer at 15 minutes. And as soon as I finish talking here, the floor will be yours for a total of 15 minutes.
You need to tell me to go.
Please go.
Oh, go. Okay. Can you hear me all right? Do I need to speak louder?
Yes.
Okay. Well, I'd like to start out with 5 overall points, and then look at some of them in greater detail. First of all, I've done many Westlaw searches of all court decisions at all levels, and I find no case in the United States or anywhere in which liability has ever been imposed upon legislators at any level, including county commissioners, for the act of placing any measure on the ballot, no matter what the measure is. Of course, state and local legislators have had authority to refer measures to voters for centuries. Oregon legislators have had authority since the adoption of the Oregon Constitution, to refer measures to voters. Of course, the initiative power didn't come until after 1902, but the referral power was there before that. The courts have found literally thousands of local referred ordinances to be unconstitutional. So the question arises, why has no local legislative official ever been held liable for the cost to the government of having the elections on those measures? And courts have found thousands of state measures referred to voters to be unconstitutional, and the question arises, why has no state legislator ever been held liable for the cost to government of having the elections on those measures? So that's the first point. The second point is that I think we should focus on the 1998 decision of the U.S. Supreme Court called Bogan versus Scott Harris. It was a unanimous decision of the court, and it held that absolute legislative immunity attaches to all actions taken in the sphere of legitimate legislative activity. And the case also indicates that immunity from liability certainly extends to all levels of local government, including specifically county commissioners. Third, the county council's theory seems to be that county commissioners can somehow be personally liable for the cost of conducting the election on a measure they refer to the ballot if the measure is eventually determined to be unconstitutional. Even in that very specific situation, the courts have ruled the other way. In Vaduva versus City of Xenia, in a decision by the Federal Sixth Circuit Court of Appeals just this August, which is which is mentioned in the October 15th memo that I provided to the commissioners, they specifically said that even if the measure referred to as unconstitutional, it doesn't matter, that absolute legislative immunity still applies to that. Actually, the case of Xenia involved the actual enactment of the unconstitutional ordinance, and the court said that doesn't matter. There's still absolute immunity for legislative acts. And, of course, placing a measure on the ballot is certainly a legislative act, and it is a less direct legislative act than actually adopting an unconstitutional ordinance, which was the case in Xenia. Nevertheless, absolute legislative immunity under the United States Constitution. Fourth, it's important to realize that the act of referring any measure to the ballot does not violate any Oregon statute. So it's unlike spending public money on ballot measure campaigns, like in the Burt v. Blumenauer case, which was forbidden by statute. And it's also unlike violating open meeting laws, again, forbidden by statute. I still haven't found any case in which liability was imposed upon any local officials, including those cases, for damages resulting from spending public money on ballot measures or violating open meeting laws. If the county council knows of any cases where liability was imposed, I would have expected that to be in his memoranda, but there aren't any. And finally, fifth, keep in mind that the Bogan decision I mentioned was issued by the United States Supreme Court in 1998, and so any case decided before that, including cases like Burt versus Blumenauer, which might have imposed liability for spending money on a ballot measure, not for the legislative act of putting the ballot measure on the ballot, would no longer be good law in any event. Now I'd like to turn to a couple of my memoranda. I provided a memorandum on I'll start with the earlier one on May 20th of this year, where I pointed out that legislators have absolute immunity under the U.S. Constitution for legislative acts, citing about a dozen various circuit court cases, several of which, of course, are based on the Bogan versus Scott Harris case. The Bogan versus on pages 3, 4, 5, and 6 of that memorandum, there are long quotations from an Oregon federal court case, Thornton versus City of St. Helens, which found that the City of St. Helens folks had absolute immunity under the U.S. Constitution for their legislative acts. As long as the decision involved an exercise of judgment on a matter of policy made by the body. And it didn't matter if the ordinance is contrary to state law, according to the federal court in the Thornton versus St. Helens case. If the ordinance is contrary to state law, the city is still immune both under ORS 30.265.3F and under the U.S. Constitution's immunity, which extends to county commissioners. In my October 15th memorandum on the same subject of immunity, I quote extensively from the Bogan case, which specifically says that the rightful exemption of legislators from liability was very plain and applied to members of inferior legislative bodies such as boards of supervisors, county commissioners, city councils, and the like. And the unanimous Supreme Court decision says, we now make explicit what was implicit in our precedents. Local legislators are entitled to absolute immunity for their legislative activities. The Bogan decision has been applied many times to county commissioners. I quote from the Kalinowski versus Lackawanna County federal case in the Third Circuit in 2013, which did that. It's been applied many times to other local legislators, including city councils. I cite cases where that's been done. And then there's the case that I mentioned before of Vaduva versus City of Xenia, which is a Sixth Circuit case decided a couple of months ago, which ruled that it doesn't matter if the legislative action taken by the local legislators is eventually ruled to be unconstitutional or not. There is absolute immunity under the federal Constitution, and that's an immunity that the state cannot waive. it is the individual right of the local legislator. The state can't do anything to waive it. I then provided another memorandum on August 7th of this year, addressing some of the cases that were cited in a memorandum by County Council, and pointing out that liability in those cases was not imposed, and that some of the cases were prior to Bogan. And I would like to take a 30-second break right now. I'm sorry. Hang on, please. And I'm back. Sorry about that interruption. And then, I have seen an additional response from the County Council dated August 26th of this year. I would just make a couple of responses to that. First of all, going back for a moment to the question of whether it matters whether the measure referred to the voters is eventually determined to be unconstitutional, there's a recent Attorney General opinion of Oregon, opinion 8290 from 2016, which points out that none of the language of ORS 249.100, 294.100, which is the statute that is repeatedly cited by County Council, or any other law of which we are aware, suggests that a public official must determine that a duly enacted statute requiring certain expenditures is constitutional before relying on the expenditure authority it provides. It's questionable whether city officials could elect not to make the expenditures directed by the statute simply because they thought the bills might be unconstitutional. So liability is not imposed, and there is no requirement that a measure be determined to be constitutional in advance. Of course, under Oregon law, it can't be, because under the interpretation of the Oregon Constitution, the Oregon courts have said that measures cannot be determined to be substantively constitutional or not until after they're enacted. On the County Council memorandum, it says I only cited one case when, in fact, I've cited dozens of cases involving local immunity under the U.S. Constitution. The County Council attempts to question whether placing a measure on the ballot is a legislative act. Well, it is a quintessential legislative act, as the Bogan decision indicates. Quote, most evidently, Petitioner Roderick's acts of voting for an ordinance were in form quintessentially legislative. Petitioner Bogan's introduction of a budget and signing into law an ordinance were also formally legislative, and that's all that matters. Because, as the court says, the ordinance in substance bore the hallmarks of traditional legislation. The ordinance reflected a discretionary policymaking decision, and that's what a legislative act is, and that's what's immune under the U.S. Constitution. The state can't waive that. Of course, putting a measure on the ballot is not a misuse of funds. There is no statute prohibiting the Commission from placing any measure on the ballot. And as no case that I've found has ever imposed liability for doing so anywhere in the United States. And of course, I can't even find a case in Oregon that imposed liability for local officials who did violate statutes, like the statute prohibiting the use of public money in political campaigns. That doesn't matter because it's not illegal or against any law for the commission to place a measure on the ballot. And that's about it.
Okay, thank you very much. We will now.
Oh, just one other thing.
Okay.
That is County Council's suggestion that the proponents should post a bond to protect the county commissioners from liability is quite the suggestion. It basically suggests that the functions of the commission be privatized and require citizens to persuade a bank to guarantee the actions of the county commission. It's really an outrageous suggestion.
Okay, thank you, Mr. Meek. I'll now call on either or both Mr. Chamoff and Mr. Gary. And could you give us your division of time for our vice chair?
Mr. Chair, Commissioners, good morning. Greg Chamoff from the law firm of Davis Wright Tremaine, appearing for the Oregon Farm Bureau and the Lane County Farm Bureau. I expect that our division of labor is going to be about 5 minutes for me and 10 minutes for Mr. Gary, although I'm going to do my best to go under my 5 minutes. I'm going to be discussing the measures themselves, those that you're being asked to refer, and Mr. Gary is going to be addressing the issue of liability. This is not a matter of your being asked to refer measures that might later be found to be unconstitutional. It is not a matter of the exercise of your discretion. There are some state laws that preempt local authority, and those are phrased in terms of enactment. You may not enact a certain kind of law. That means you can vote on it, but you can't enforce it. ORS 634.057 is a much more prohibitive law. That law expressly prohibits the adoption of a law that regulates pesticides. Adoption means to vote. It was for that reason that last month the judge in the Lincoln County case, ruling on a measure that is substantially the same as the measures you are being asked to refer, that judge ruled the measure is entirely invalid, all of it, because it should not have been adopted in the first place. Referring the pesticide control measure would be entirely outside of the authority that you have because the state has prohibited the exercise of that authority. With respect to the community rights measure, that which proposes to put state law and federal law behind the law of this county, in that opinion, the Lincoln County judge said, quote, "There is simply no authority for the proposition that the people of Lincoln County are granted an inalienable right to local self-government which preempts any authority of the state," close quote. The court didn't say it was a matter on which reasonable minds could differ. The court said there was, quote, "no authority," close quote, "at all," meaning you do not have the authority to have a vote on a measure that would offer that policy choice to voters. And I will be happy to cede the remainder of my time to Mr. Gary.
Mr. Chair, members of the Commission, good morning. I'm Bill Gary. I represent Stan Long, who is a resident of Lane County, longtime resident, and a concerned citizen. He has been a party in each of the 3 lawsuits that have involved the proposed initiatives that bring us here today. He has prevailed in every one of those lawsuits, and as a result of prevailing in those lawsuits, he has accrued for himself absolutely nothing other than the benefit of good government, which he has spent his entire adult life being devoted to. The question that I want to address this morning is whether the county commission should refer a meaningless measure for a meaningless vote of the people. There's not really very much dispute that the two measures in question are facially unconstitutional and can never take effect. Now, Mr. Meek has assured you that if you were to decide to incur the expense and the trouble of an election for these facially unconstitutional measures, you would enjoy what he called absolute constitutional immunity for legislative acts. First of all, there's nothing in the United States Constitution that addresses legislative immunity, save and except the speech and debate clause, which applies to the Congress of the United States. Secondly, the cases, every single one of the cases that Mr. Meek has cited to you are cases in which federal courts are interpreting federal law, specifically 42 U.S.C. Section 1983, which gives individuals the right to sue public officials acting under color of state law who violate their civil rights. No one has suggested that a referral of any of these measures would result in a 1983 lawsuit. And so therefore, every single one of the cases that Mr. Meek has cited to you are completely beside the point. The question is a question of Oregon law. And let me talk to you a little bit about what Oregon law provides. First of all, the Oregon Constitution, recognizing the longstanding common law rule of sovereign immunity, the old doctrine that the king can do no wrong, said that the legislature has the power to waive immunity. And the legislature has done so in multiple situations. The Oregon Tort Claims Act, which allows citizens to sue if they are injured as a result of some wrongful conduct by the government, is one example of a waiver of immunity, but it's not the only one. The one that matters here today is ORS 294-100. That statute specifically says that a citizen can sue public officials who unlawfully expend public funds, and if they behave willfully and wantonly. That's a pretty sobering thing for a public official, because what we're talking about is personal liability and a personal duty to defend, because obviously recouping misexpended public funds would not work if the government were to defend the unlawful expenditure claim. So when a public official expends money for any purpose, a citizen has the right to take it to court and say what you did was unlawful. And the defense, it basically boils down to three things. It wasn't unlawful for me to do what I did. I didn't act in bad faith. I didn't act willfully and wantonly. And as a part of that second defense, I was following my attorney's advice. I acted on advice of counsel. That is a defense. So Mr. Meek has told you, you can go ahead and refer this. You don't need to worry about it. You won't be found personally liable. Mr. Meek is not going to defend you if a lawsuit is brought. Mr. Long, my client, firmly believes that not only would it be a waste of taxpayer money to refer patently unconstitutional measures to the voters for a meaningless vote, but that in the circumstances of this case, it would be unlawful for you to do so. This isn't a situation where there is a good faith argument for a change in the law, such as states that want to ask the United States Supreme Court to revisit Roe versus Wade. This is a case where there is no good faith basis to argue, as one of the measures does, that the laws of Lane County shall prevail over the laws of the state of Oregon or the laws of the federal government. That just flies in the face of 250 years of settled constitutional law. It's not right. And if you, in the face of that obvious unconstitutionality, elect to ask the voters to approve a measure that purports to do that, you would be acting unlawfully. Now, there are a lot of different attorney opinions. You've heard two of them already, three of them, I guess, between Mr. Chamath, Mr. Meek, and myself. But there's only one opinion that matters for purposes of ORS 294-100, and that's the opinion of the county council. The advice of counsel defense does not mean if you can find some lawyer who expresses an opinion, you can rely on it. It means if you rely on your attorney's advice, you will be protected. Your attorney has advised you that it would be unlawful for you to refer these measures. So you will not have available to you the advice of counsel defense. The question is, how lucky are you feeling? Do you want to take the chance that Mr. Meek is correct, that there's not going to be a problem? And let me assure you that a referral will result in litigation under 294-100. This isn't an idle threat. Mr. Long has engaged in 3 different lawsuits because he cares about the rule of law. He will do it again. It shouldn't take the fear of personal liability for responsible county commissioners to recognize that submitting a measure to the voters that is patently unconstitutional and can never take effect is a waste of public resources and of the public's time and attention. And so, apart from personal liability, I'm here today on behalf of Mr. Long to urge you to do the right thing, which in this case means doing nothing. Thank you.
Okay, thank you. And now we are turning to Mr. Dingle for a presentation. I know you said you probably wouldn't take this much time, but for up to 5 minutes.
Chair, thank you. Members of the board, briefly, I've submitted, I don't know how many pages of written material. That's why I only took 5 minutes. It's probably better that I simply address part of the question and answer period. To be clear, this is a weird or unique situation because the board has waived attorney-client privilege, so it's not typical that we'd have this kind of conversation in a public session, but the board has done that. I've provided the written arguments. I'm not going to go through point by point. I would point out a couple of things to Mr. Meek. He didn't read my memorandum very carefully. There was a case where individual county commissioners were imposed a financial penalty under 294-100. And there was not a finding that the theory that they were, where that liability was opposed existed prior to the case, and that's dumb-dying. There was no case.
I read that. I read that case, and it doesn't say
Excuse me,
that
Mr.
liability
Meek.
was imposed.
Excuse me, Mr. Meek, I'm
Okay,
speaking.
let's have Mr. Dingle finish, and Mr. Meek, you will be given your summary time.
So anyway, there was no case prior to that time that, that held that serial meetings violated the Oregon Public Meetings Law. There was in that case an opinion by county council that had said that that conduct would violate, at a minimum, the spirit of the law. So my point being that the idea that there has to be some sort of finding prior to that time is not required. It is ridiculous to argue that, in my opinion, that you can do whatever you want and unlawfully spend money and that you're absolutely immune from it. As Mr. Gary pointed out, all of those cases that council is citing talk about immunity from 1983 actions. This isn't a 1983 action. This would be an action under 294-100. The reason that I suggested, and again, the reason I mentioned the bond is if they're so sure, if Mr. Meek is so confident in his position, then he should be willing to put up the money to protect you from that. In my opinion, the law is clear here. Every single court that had, with save one, which was ultimately reversed in a rather unusual way, has rejected every single one of Mr. Meek's arguments. Every single court. Different judges in different counties, judges at the trial court level, and judges at the appellate court level have all rejected their arguments. And again, when I look at it, if you read the opinion from the judge in Lincoln County, it's very clear. What he is proposing is not supported by law at all. I want to close with this. There is a way, and I agree, if the proponents want to go through the initiative process and follow the rules that apply to initiatives, it can get to the ballot. Absolutely. That is not what's being requested here. That's all I have, and I'll answer questions later.
Okay, thank you. We have set up a pretty rigorous schedule thus far, holding everyone to their precise time, but now we have a pretty open period here at 9:35-ish for a lengthy period of time for the board to ask questions and make comments and have discussion. And so I'd like to recognize whichever commissioner would like to go first. So who wants to go first in the questioning? Feel free in the questioning to direct questions to the other lawyers. I'll invite Mr. Chamoff and Mr. Gary up to the table here, and I will virtually invite Mr. Meek up to the table here so that they can take questions from the commissioners if the commissioners want to make comments or questions. So any commissioners want to be recognized? Seeing no one that wants to be recognized, I'm ready to go, so I'll ask a couple of questions. I'm interested in hearing more about the byplay between the Bogan versus Scott Harris case. That's the 1998 U.S. Supreme Court case under the Civil Rights Act that Mr. Gary pointed out was under the Civil Rights Act, that said that local legislators, county commissioners are absolutely immune from liability stemming from their performance of duties, and the relationship to the Oregon statute that was also referenced, ORS 294-100, that is a different type of law, but it imposes liability on public officials who expend money without proper authority. So I'd like each of you, Mr. Gary and Mr. Chamoff and Mr. Meek, I'd like you to address whether you think those laws apply in the situation in which the commissioners are being asked by the public to put certain measures onto the vote and vote in the form of a referendum. So who wants to take that first?
Well, I'll jump in. The answer is no. The federal cases, including the Bogan case, don't have any application in the context of the state law question of liability under 294-100. And the reason is pretty basic. We have a dual system, a federal system, where there is federal law that is interpreted and applied by federal courts and state law that is interpreted and applied by state courts. States can decide for themselves the extent to which they will waive immunity and allow lawsuits to be brought. And the federal court, there's no federal question presented. So if a lawsuit were brought under ORS 294-100, the question would be a question of state law, and you would get a decision from the circuit court that could be appealed to the Court of Appeals and then to the Oregon Supreme Court. But there would be no basis upon which you could seek review from the federal court because it's not a federal question. It's a question of Oregon law. And so those cases, to the extent that they have any value at all, it is their persuasive force. And because they're answering different questions, those cases have little or no persuasive force in the context of 294-100.
Okay, Mr. Chamoff, do you want to add anything?
Mr. Chair, no, thank you.
Okay, Mr. Meek, you heard my question, so please feel free to answer if you want to.
All you have to do is read the cases. The cases, by their own terms, are not limited to federal actions under 1983. Let's just look at the most recent Oregon Federal District Court case, Cascadia Wildlions versus Kitzhaber, 2012. States it is well established that legislators are absolutely immune from civil suit for actions taken in their official lawmaking capacity, citing Bogan. There's no limit to there about suits under 1983 or suits under federal law. It is a federal constitutional right of local legislative officials to be immune from liability for their legislative acts. And no one can dispute that placing a measure on ballot is a legislative act.
My second question goes to cases under ORS 294-100 that have been decided by the Supreme Court of Oregon or by the Oregon Court of Appeals interpreting that statute. Do any of the attorneys present have any case that says that the county commissioners or city councilors that have referred measures to the ballot and then subsequently that was ruled improper, where civil liability was imposed on the elected officials who voted to put the measure on the ballot?
I can answer that question. It's a very easy answer. No, that has never happened. In addition, I can't find any Oregon case where liability was imposed under that statute for any reason. In Burt versus Blumenauer, the case ends with a remand, and what eventually happened is not reported. The Dundee case, I read the Dundee opinion, and there's no indication in it that there was any imposition of liability upon the violators of the Open Meetings Act. Of course, the other difference is that local legislators can violate the law, like the Open Meetings Law, but there is no law against putting a measure on the ballot. No matter what the measure says, there's no law against putting it on the ballot.
Yeah, Mr. Gary, could you give your answer to that question?
Yeah, Mr. Meek is correct that at least I haven't found any case involving a referendum that resulted in personal liability. I also have not seen, and I'm not aware of, any case in the history of the state of Oregon where an elected body such as county commissioners have referred a measure to the voters in the face of their lawyers' advice that doing so would result in the referendum of an unconstitutional measure that could result in personal liability. So this is a rather unique circumstance that we have here. And with respect to the question of whether there are any cases in which personal liability has been imposed under 294-100, I can only tell you that as members of this body know full well, to say that there has never been such a case can only be the result of willful ignorance. Of course there has been, and there will be again, to the extent that public officials engage in conduct that it results in an unlawful expenditure of public money.
Okay, I have other questions, but I'd like to make sure the commissioners, now that I've broken some ice here, if any other commissioners have questions. Jay?
Sure. So I guess one question real quick is, does placing a measure on the ballot expend money? And my personal answer to that is yes. Every line item on a ballot costs us money in the elections department, but I want to turn to the county administrator possibly to answer that because he controls our budget.
Well, the cost of, yes, there is a cost of a countywide election, and that includes staff time involved with the printing, printing of ballots. The cost of mailing the ballots is the primary cost, and the total cost of each election depends, per issue depends on the number of items on the ballot.
But every additional item on the ballot costs additional money.
Yes.
Thank you. I just want to make that clear, that placing a measure on a ballot is expending public money. Second is adopting a budget of legislative action.
I think pretty clearly it is, yes.
Yeah, it's actually a required legislative action under Oregon law that we adopt a budget every year. The Dumb Die suit was about adopting a budget. Clearly a legislative action. And the part of the knowingly violating the law was doing it in secret through serial meetings. And in fact, if I don't know if Mr. Meek has actually read the decision on page 43, plaintiffs are entitled to request their attorney fees and costs pursuant, and plaintiffs are likewise entitled to a judgment against Handy and Sorensen individually, awarding any attorney fees and costs jointly and severally against them individually pursuant to ORS 192-684. And if you go back and read it, the reason he assigned that individual liability was they knowingly violated the law after receiving a memo from county council warning them about serial meetings. So what, I don't, Bogan was in place. 1998. Dumb Die was 2010. So how could an Oregon court, rule that there was individual liability by two commissioners for knowingly violating the law during a legislative act if Bogan gives you complete immunity? That's my question for Mr. Meek.
In order to have immunity, you have to raise it. There's no indication that anyone in the case raised it. Number two, what I pointed out is there's no liability under 294-100. What the liability was imposed was for attorney's fees. It wasn't for damages, and the attorney's fees are imposed because of the parties' disregard for and doing things in an outrageous manner contrary to the advice that they got. In addition, there is a law against violating the open meetings law and having secret meetings. There is no law against putting any measure on the ballot.
I'm sorry, but there's a law against local regulation of pesticides. Is that not a state statute similar in ORS to the open meetings law? Isn't it statutory?
It's not violated by putting a measure on the ballot.
knowingly putting a measure on a ballot that's been ruled by the courts in other jurisdictions to have violated that statute. I'm not talking about unconstitutional. I'm talking about statutorily against the law. I'm sorry, I'm just not buying it. I'm not buying the fact that, one, you're providing us legal advice and you're not my attorney. I don't believe your opinion provides me any affirmative defense.
I'm not providing you legal advice.
It sure sounds like it.
Absolutely not. You're not my client. I'm not providing you legal
Okay,
advice.
I just want to clarify that. So you're not, which means anything you're telling me is not giving me any affirmative defense.
That's right. Your own attorney is taking away your defense.
No different than the county council took away the defense in the Dumdye case.
I would also point out that the Attorney General's opinion in 2016 states that a public official may avoid personal liability for an otherwise unlawful expenditure of public funds under ORS 294.100 if the official relies in good faith without personal benefit upon the advice of counsel, whether public or private. And it cites the Belgrade case in which the defendant relied upon the opinion of a private counsel.
You know, I can't see how anyone in good faith can claim that they don't know that this particular ballot measure violates Oregon statute, and how anyone in good faith does not know it's going to cause the expenditure of public money to run the election. Yeah, I don't see that as a viable, positive, and affirmative defense.
Okay, do other commissioners have questions?
Oh, heck, why not?
Okay, Commissioner Bernie?
First, to Mr. Gary, no, I'm not feeling lucky, but I don't appreciate that as the big question in front of us. I'm trying to uncover the legal realities. The one reason I'm not feeling lucky is because this discussion has nothing to do with the pros and the cons of the initiatives that are being requested. It has nothing to do, which I will get into later in this discussion. It has nothing to do with the desire to have the public go through the same kind of education process that we are going through. What it really has to do with is legal liability for even allowing the public to vote on a measure by the action of this body, given the fact that the effectiveness of the action would be probably null and void given state law preempting. So I just want to point that out. I'm asking for clarification here because unlike I don't always have the answers to the questions I ask. So and forgive my naivete. My understanding, and I'm asking this of our county council, my understanding is that the liability here is the potential cost of litigation after an election, not the cost to the county of putting something on the ballot, but truly I don't know the answer, but the cost of, we refer to ballot, we have an election, one group wins, the other group loses. They're going to litigate. They're going to litigate against one another. And it will continue and continue, and we've seen that pattern occur. And my understanding is it's the cost of that subsequent litigation that becomes a liability personally for commissioners. Am I wrong?
No, it's both.
Okay.
It's both. And in the case of the Lincoln County matter, I think I mentioned it in my memorandum, one of the additional costs, which county council told me he wasn't going to pay, was a bill from the state for an additional $10,000 that they spent doing hand spraying because of the legal uncertainty. Apparently they were doing some spraying before this decision came out, and so in an abundance of caution, the state said, well, since there's not a final ruling from the court on this, we're going to hand spray, and by the way, here's the bill to Lincoln County for $10,000. Now, theoretically, if the state pressed that and it ultimately was determined that the county owed that, that would also be an example of a cost that would go into it, that would be personally liable. I think it's important to remember how that measure got there, because that measure was an initiative, and it was, it wasn't referred by the board. That was a voter-driven initiative, and then it was the subsequent litigation that, so there is no issue of personal liability in the Lincoln County case, is what I'm saying. I didn't mean to by making that example, but I use that as an example of a cost. If the board would refer it, I think someone would be entitled to ask for not only the additional costs associated with the election, it would be any of the, potentially any of the attorney fees costs that are associated, and any of those, what I call collateral things like that. And I'm using that handspring thing as an example of another thing that could be liable.
And thank you. And if I may, I think you referred twice to an initiative that did not go through commissioners, once as a remedy for the people that would like an initiative on the ballot, and once now. Can you explain what the difference is here?
Sure. Mr. Meek is absolutely correct. I don't think Mr. Gary, Mr. Chairman, and I dispute this. It's well settled in the state that if you, as citizens, either at the state level or at the local level, follow the appropriate procedure, comply with the statutory and constitutional requirements, they can put an unconstitutional measure on the ballot. That does not involve any action by the board. The board can't stop that. So the board's not taking any action. Once they meet all the statutory, gather the right number of signatures, comply with single subject, full text, separate vote if it's a charter amendment, it goes on the ballot. It goes on the ballot.
Forgive me, I don't mean to hog. I'll just one last follow-up. And that would require, my sense is that this group feels they've done that already, and that would require them basically to do what?
Well, under the current state of the law, they have got the first two. These two petitions have been were past the initial test, which was single subject, full text. They both were struck down by judges as violating the separate vote requirement. So they clearly would have to do something different with the format of the measures. I use the example, the easiest one I think for most people to understand is the Crime Victims Bill of Rights case from a number of years ago. The crime victims folks put together, and I don't remember the number, but it was 10 or 11 or 12 individual rights that were very disparate, lessening animus jury, certain evidentiary rulings, right to speak at sentencings, different things like that. Voters adopted it. The court post-election struck it down as violating the separate vote requirement. And so when that measure went back, the circulators actually had to have separate, you had to sign, if you wanted to support all of the different rights, you had to sign whatever it was, 10 or 11 different sheets, because and then when it went to the voters, they voted on each individual right. And that's what they'd have to do here is break up the substance of it to where it didn't violate the separate vote requirement, and then present it to the, gather the signatures in that format, and then present it to the clerk in that format. And if it passed, then it would go on the ballot in that format. Thank you.
I would just point out that none of the litigation that was just mentioned is final, that the two cases are both of the Oregon Court of Appeals.
And they are currently binding on these commissioners.
Okay,
These commissioners have nothing to do with those cases.
We're in the district, they were approved.
okay, Commissioner Bernie, are you concluded with your remarks or comments, questions?
At this moment,
At this
yes.
point, okay. Any other commissioners want to be recognized? Okay, yeah.
Thanks. I just have a couple of very simple questions in very simple terms. A number of people may be watching, and just like, and this is just for clarity, if we place a measure on the ballot and it passes the vote, would it ultimately be ruled void by Oregon courts?
I think yes. Unquestionably, yes. That's what the Lincoln County judge concluded only applying the Pesticide Act, saying that she didn't have to go through the analysis under the Forest Practices Act. I think it's preempted, it's my opinion, it's preempted by both of those statutes.
There are two different measures. One of them is that. The other one is the community rights measure. And there's no decision about the constitutionality of the community rights measure. As far as the aerial spraying measure, there is the opinion of one circuit court judge in Oregon, and that will also soon be appealed.
Okay, so then let's have a yes or no on this. If this were passed at the ballot, would it be ruled null and void based upon current court decisions?
If you credit the one judge in Lincoln County, it would be ruled unconstitutional. It would be ruled a violation of the Forest Practices Act.
Are you
But that's
discrediting the one judge, Mr. Weeks?
That's just one judge in Lincoln County. Circuit court judges are frequently overturned, and we'll find out if that's the case here.
Okay. Then that's really the only question. I just want to make certain that that we understand that if we placed it on the ballot and it passed, it would be ruled null and void based upon current court decisions, certainly pending the appeals court. But I guess everybody in the room knows that it would be ruled null and void if we put it on the ballot, right?
No. We don't know that. We know what one judge in Lincoln County says.
We know what one judge in Lincoln County said. Okay, great. Thanks.
Okay, Commissioner Buck.
So if we play this out and say we put it on the ballot and people vote on it and it passes, turns out that maybe it's overturned, what is then the right way, in your opinion, for this, if voters wanted to get this in front of the public for a vote that did not violate these terms as you've laid out, what is the avenue that they would use?
They would use as I described earlier, they would use the initiative process. So they would, but they would have to change the format that it's in to comply with the currently, two circuit court judges have ruled that that these measures, one and the other, violate the separate vote requirement. Now, we did support a measure, a statute at during the last legislative session that would have had that examination done up front at the same time that the single subject and the full text review was done. Because the current law in the state of Oregon is that, at least the one in Lane County, is that the clerk makes that review only after they've gathered the signatures. And I think everyone here agrees that doesn't make a lot of sense. But that's the way that the courts have interpreted the statute. So we certainly supported Senate Bill 368, which would have said, you do all those things up front, and by the time you start circulating petitions, you know that it would comply, that if you got the requisite number of signatures, it would get to the ballot. And now that doesn't mean that it might not be ruled post-enactment unconstitutional, but it would at least get to the ballot and the voters would vote on it. And I don't know if Mr. Gary or Mr. Chambers disagrees with that.
I don't, but I understood your question a little bit differently. If the voters of Lane County want to ban aerial spraying, how do you go about doing that? And the answer to that question, I mean, I think your counsel is right. That's how you get the measure on the ballot, but you're still going to run into preemption at the end of it. So it's not going to take effect. The way you deal with that is you go to the legislature, which passed the preemption statutes, and ask them to change it. It's kind of odd for active citizens who care deeply about an issue like this to spend their time asking county voters to overrule the judgment of the state legislature. County voters don't have that authority, so they should take their matter to the legislature and make their case there.
That's correct. I misunderstood. I thought you were asking how they would get it in front of the voters. Ultimately, if they wanted to give effect to what these measures do, they would need to repeal or change the State Pesticides Act or the Farm and Forest Practices Act.
And if the legislator does not do that, then
That's the way our Republican system of government works. Change the legislature. That's what you do.
Okay, are you concluded? Okay. I just wanted to ask the panel of lawyers here that there's been an assumption that the Board of Commissioners has a certain type of referendum that's being considered. I just want to clarify that we've had the proponents of measures bring drafts of measures to us, but we have never considered or drafted a measure that we would be that we've actively considered. So we're kind of talking about a referendum that hasn't been proposed. We're talking about an initiative that's been turned into a referendum that the board may or may not want to alter and put out for a vote. But I'm just curious whether there's something in the initiative or in the redrafted initiative that the proponents have brought in, if there's any component of that that could be sent out to the voters that would be proper and within the authority of the Board of Commissioners.
Well, that actually raises a good point, Commissioner, because it is important to keep in, and I know it's hard for non-lawyers to keep some of this stuff straight. The initial initiatives were proposed as charter amendments, and those are then subject to full text, single subject, and the separate vote requirement. And those are the ones that Judge Rasmussen and Judge Shanti ruled on. As I understand it now, they realize, I think the proponents understand that couldn't, even if the board were to refer those as a charter amendment, they would still be subject to being the same challenge, which even Mr. Meek has to acknowledge is binding. So I think what they've now proposed is that these be ordinances. So they're not a charter amendment. So 203725 sub 2, the separate vote doesn't apply. I know that if you read what was interesting is if you read the Lincoln County case, Lincoln County Council argued that there was an exception for the, in the Pesticide Act for county or city property, and that it could apply on that. And the court actually struck that down because what the judge pointed out was it doesn't permit an ordinance or regulation. It allows a policy. As a matter of policy, a person can do it. So I haven't split these out, but my sense is that the things, and I'm not going to speak for the proponents, but just from hearing their arguments, my suspicion is that there is nothing that they really want in there that wouldn't be subject to being struck down, because I think anything that would effectively carry out their ultimate goal is going to be preempted either by the Pesticides Act and or the Forest Practices Act.
What about, do any other lawyers want to add anything to that remarks, Mr. Dingle made?
Mr. Chair, I just wanted to say my remarks have been directed at the proposed ballot measures referred as ordinances. And if the commissioners wanted to craft a referendum, I'd like to have the opportunity to review it before I comment on its enforceability. But there's one other thing to keep in mind, and that is the referendum authority is limited to legislative matters. And so to the extent you wanted to adopt a policy to, for example, not allow spraying on county lands, I'm not sure that would be a proper subject of referendum either. So, but it just, the devil is in the details, as you know, when you're looking at measures like this.
I think what Mr. Gary is referring to is, yes, it has to be legislative and not administrative is what you're talking about. Yes, that's another, my memo, I think, discusses all of the different elements that things have to comply with, and one of those, of course, is it has to be legislative, not administrative. It has to be a matter of county concern, single subject, full text, and if it's a charter amendment, comply with the separate vote requirement.
Mr. Chamoff or Mr. Meek, you want to add anything?
Yes. No county has ever applied the separate vote requirement to a proposed charter amendment initiative until your county clerk started doing that a couple of years ago. It has never been done before. It has never been upheld by an Oregon appellate court. We'll be finding out soon whether they will uphold the disqualification of a county charter amendment on those grounds. So I believe that it was Mr. Dingell who was talking about that and how that separate vote requirement would also apply to a referral by the county commissioners. I don't believe that's true because I don't believe that the single decision of the county clerk in Lane County and the Lane County Circuit Court will be upheld on appeal, but we'll find out fairly soon.
And just to be clear, Mr. Meek, I was only talking about if they were to refer a charter amendment. You don't disagree that currently this commission and our clerk is bound by a Lane County Circuit Court judge's order?
I'd have to go back and look at that since none of the courts that I'm involved with has been considering applying a separate vote requirement to a county charter referral. I really can't say what the law is on that.
Well, I guess what I'm saying is you don't disagree that there is currently a binding Lane County Circuit Court ruling that says that the separate vote requirement applies to the charter amendment that's been proposed.
I agree that that was the ruling on the community rights charter amendment. Yes.
Okay. Mr. Chamoff, would you like to make any further comment before I ask my second question?
Thank you, Mr. Chair. I think in answer to the question you asked, what could you do? As I understand it, under the opinion by the Lincoln County judge, this commission could, if it wanted, adopt a policy that lands owned by the county would not be sprayed, and that you would have that public policy choice. It doesn't involve a vote by the people, but you, exercising your own power, could make that decision.
Okay. That's great. That's a great lead into my other question, and that is that many times we see local governments making referenda to the public, asking advisory questions, specifically whether or not the public wants a certain policy enacted or not. It's non-binding. It's simply a statement on behalf of the voters of that community. I'll just call it, for general purposes, an advisory vote. What is your view on the authority of the Board of Commissioners to put out for the public an advisory vote on a matter of federal or state matter?
Mr. Chair, Commissioners, subject to my colleague disagreeing with me, I think that would be within your ability. What state law prohibits is adopting a law that regulates pesticides. If you wanted to ask your constituents through a measure, what are your feelings about pesticides, that would not be preempted.
Okay.
I agree that would not be preempted. I'm not certain whether that is within the board's power or not to call for an advisory vote, particularly an advisory vote on a matter of state or federal law. That gets into the complicated interplay between the initiative and referendum power and the county's home rule authority. And I think that would be an interesting question to have to dissect.
I'll just hold Mr. Meek's response and just say, I'm aware, for example, in Eugene, where voters have been asked, do you want to build a West Eugene Parkway or not? It wasn't a decision of the city government to build it or not. It was an advisory vote, from my understanding. So that would be an example of an advisory vote. Yeah. some sort. Mr. Meek, I cut you off there, so please feel free to respond to my previous question.
Government entities in Oregon can place advisory votes on the ballot. The leading case, the City of Eugene versus Roberts, a 1988 case in the Oregon Court of Appeals, which has been affirmed by the Oregon Supreme Court in the same year.
Can you tell us more about that case?
I briefed it about a year ago in a case that is now up at the Oregon Supreme Court involving whether an initiative, a state initiative, can constitute enactment of an Article 5 convention call under the United States Constitution. The Oregon Supreme Court granted review on that a couple of months ago. And one of the arguments there was that that proposed statewide initiative would just be advisory. And so I looked up the laws, and there's nothing that forbids it. And in the City of Eugene versus Roberts case in 1988, I'm trying to figure out what it was about, but from my memorandum here, I can't determine what it was about.
Mr. Gary has been legal counsel for the City of Eugene, so maybe he knows.
Yes, actually, in 1988, I was the Deputy Attorney General, and I argued City of Eugene versus Roberts against the city and on behalf of the state. And the question in that case had to do with a nuclear-free zone ordinance. And what the city wanted to do was to give the voters a menu of options. Do you want option 1, option 2, or option 3? And the Secretary of State refused to put that measure on the ballot because state law requires that any ballot measure be subject to a yes or no answer. The city took the position that they had a home rule right to run their government any way they wanted, which is a proposition that I agreed with then and now. But what they didn't have was the authority to compel the Secretary of State to run the election the way the city wanted to, contrary to state law. So I'm not sure that case really gets to the question of advisory votes at all.
Is there a statutory provision for advisory vote that local governments, such as cities and counties, have to follow when they want to put up an advisory vote?
I don't know.
Okay, well, I figured there would be some follow-up to today's work session. So are there other questions by commissioners? Commissioner Farr?
Thank you, Mr. Chair. You know, I'm going back to simple questions. If my previous question, the answer was yes, would it be overturned, or would it be ruled null and void or preempted? So if that is the case, and we were to put this on the ballot, wouldn't that argument be a pretty strong argument for the opponents of the ballot measure?
Mr. Chair, Commissioner Farr, one would hope.
I knew the answer to that. I'm not a lawyer. So, okay, so if we were to put it on the ballot, it would be preempted should it pass. However, the opponents of passage would be free to argue that, well, you can pass it or not, but if it passes, it will be preempted. So that would be a strong case to vote against it, should it go on the ballot. Okay, I'm just I'm thinking from a voter's point of view right now, and you know we have to make a decision here at some point, and we're to me wasting time, effort, and money if it's going to be preempted doesn't seem to make a great deal of sense.
Any further response from any of the lawyers?
Just noting that, of course, preemption has not been decided on the appellate level yet.
Okay, thank you.
And so, Mr. Chair, I guess I'll rephrase my response there. We have a yes from our attorney that it would be preempted, and a maybe from Mr. Weeks that it might be preempted, might or might not be preempted. Okay, thank you.
Okay, Commissioner Joe Berney wants to be recognized.
Thanks a lot. First, I'd just like to point out that, to my knowledge, and I'm ready to be told I'm wrong, to my knowledge, this is the first time that the county commissioners have waived attorney-client privilege and released documents to the public on this issue. It's fascinating. I remember when I was out campaigning and talking about citizens ought to have the ability to vote on things that affect them. Obviously, there are contexts for that. I'm learning more and more about those contexts. I was surprised when I was told the community rights group actually didn't support what Lane County supported, because I was out there preaching it, which was that these initiatives ought to be looked at in advance for consistency and adherence so that people's time wasn't wasted gathering signatures for no reason. I still believe that's a good idea. I've heard thus far that there are routes to go on a local county initiative if people were willing to take the time. I have suggested somewhat naively in a conversation with the community rights people that it seems that the state level is the level at which to deal with this. I think this advisory vote is intriguing, to me at least, in that I've not heard anyone say that it is that commissioners would be liable, unless you want to tell me I'm wrong. I'm paraphrasing my knowledge here, that commissioners would be liable for seeking an advisory vote. I think that would, to a degree, at least create an education campaign, both pro and con, whatever the initiative is, which would be good for the public. I'm eager to hear if I'm wrong that an advisory vote would be an idea that would create liability, especially if it were non-binding, at least an opportunity for citizens to weigh in on an issue. And I'd like to read something that was in the Register Guard this morning that to me gets at how this just keeps going and going and going. Backers of rejected ballot measures proposed by environmentalists to tighten Oregon's forestry have filed a lawsuit saying Oregon Secretary of State Bev Clarno broke with legal precedent and based her rejection on bad advice from political appointees. The Oregonian reported that the lawsuit, filed Monday in Marion County Circuit Court, asked the judge to overturn the rejection and award attorney's fees. The ballot measures, initiative petitions 35, 36, and 37, are largely the same. They call for tightening the state's aerial herbicide spraying laws, which today offer some of the West Coast's weakest protection for people and fish. They call for more logging, restrictions on steep landslide-prone areas. They would prohibit conflicts of interest for state forestry board appointees who today can set policies that benefit their own companies. Clarno, a Republican, rejected the initiative September 24, saying they are covered by more than one subject. That they covered more than one subject. The Oregon Constitution says each ballot initiative can only address a single policy topic, and on and on and on. That to me says there will be lawsuits regardless of whether this is constitutional or not. If it's unconstitutional, it seems it would be in poor judgment for commissioners to subject themselves to liability and take themselves out of people that they actually are more politically appreciative of and aligned with. But I still want input on Commissioner Sorensen's advisory vote concept. If that requires more study, so be it. But if that's an opportunity, at least to gather more public opinion and educate more people on various sides of an issue, I would welcome it.
I haven't looked at the advisory thing, but I actually did exchange information with the Secretary of State. And just to be clear, what they did was in consultation with the Attorney General. The Attorney General, as I understand it, did not do a formal letter or opinion as they typically do, but they did determine that it violated the single subject rule, that they were trying to put two things that were unrelated together, not the separate vote, just the single
Oh,
subject.
I'm sorry. The RG isn't always right. I was just reading.
Well, I actually assumed it was a separate vote, and the person from the Secretary of State's office actually corrected me and said, no, it wasn't the separate vote issue it was the single subject.
Hey, Commissioner Farr.
Thank you. And I was on the Eugene City Council from 1995 to 2003, and again in 2011 and 12. Mr. Gary, your firm was our attorney at the time. We went in-house while I was a city councilor. And I was there for the advisory vote on the West Eugene Parkway and the other vote on the West Eugene Parkway, which was not advisory. The advisory vote, overwhelmingly, people supported the West Eugene Parkway. And the city council, after I left the city council, decided to disregard the advisory vote. So that's the value of an advisory vote. You can have one, and no matter what the people say in advice, you don't have to listen to the advice. You go against it if you want to.
Okay, Commissioner Bozievich.
Thank you. And one of the things about those advisory votes on the West Eugene Parkway is they both pertain to something that was a matter of a city concern and under the control of the city ultimately in their transportation system plan. Our charter preamble basically says, we, the people of Lane County, in order to avail ourselves of self-determination in county affairs to the full extent permissible under the Constitution and laws of the state, by this charter confer certain powers. So the question is, yes, we could refer something, but I think we may even get challenged on referring something that's a matter of state concern and is not under our power under the Constitution and laws of the state. And I would guess that we would see litigation about even referring a question that pertains to something we've been preempted.
Do either of you, does anyone, Mr. Meeks,
Well,
other attorney?
to the extent that's a question, yeah. I mean, that's what we set this up for discussion, which I would rule was discussion, but if it's a question, then we could have an answer to.
No.
I will say on behalf of Mr. Long, like your own counsel, I would need an opportunity to look at this question, and it would be helpful in doing so to have at least conceptually what that advisory vote would ask. And I'd be more than happy to weigh in with your counsel or with the commission on that, but I'm not in a position to do so this morning.
Mr. Chair,
You want to add something, Mr. Chamoff?
Mr. Chair, no, just to echo Mr. Gary's comment.
Mr. Meek, do you want to add anything?
Not on that subject, no.
Okay. So any other commissioners want to be recognized? Okay. I'll jump in and just ask this question. As the lawyers know, we set this up as a kind of lawyer-only thing because we had extensive public comment opportunities ahead for the general public, but we wanted to really focus in on some of the legal issues that have been raised. And I'm wondering if the lawyers all could listen to this question and see if you can get your answer, and that is, with regard to the potential referral of the aerial spray measure, if that were turned into a advisory vote request, that the Board of Commissioners would take that potential aerial spray measure, turn it into an advisory vote, would you be willing to give us your views on that? Not today, but just in a written form that we could then confer with our attorney on?
Mr. Chair, of course.
Yeah.
Yes.
Okay. What about you, Mr. Meek?
Are you asking for views as to whether that's something that the commission can lawfully do, or?
No, I'm asking if you're willing to, at some point in the future, no real pressure, but at some point in the future, just give us your client's view on the legal authority of the board to make an advisory vote on the aerial spray measure.
Oh, well, I can give you that opinion now. I think that you can. And I looked up the City of Eugene versus Roberts decision, and it says there's nothing about the word advisory that makes a question something other than a, quote, proposition or question under Oregon law, and therefore something other than a measure within the statutory definition. So I think you can do an advisory question if you want.
Mm-hmm. Okay. All right. So I'd like to ask the commissioners if you have any other comments or discussion, and if not, then my proposal would be that we go to the summary comments by Mr. Meek, Mr. Chamoff, and/or Mr. Gary and Mr. Dingle. But before we go there, I wanted to give you one last opportunity for any comments before we have the summary comments from the lawyers.
We get one last chance.
And we will also have another opportunity following the conclusory summary remarks from the lawyers. Yes. Go ahead, Joe.
Not Commissioner Joe Burney.
Commissioner Joe Burney.
I just want to acknowledge and thank the attorneys present. I also want to acknowledge, actually, and underscore this, all of the people in both the community rights and aerial spray group. I know how many years you've been involved in the effort, and I know how vitriolic, how to your hearts this issue is, and I want to thank those that were here last night as well as this morning. And I mean this sincerely, and I want to thank those from the other side of this particular issue. Last night, we had the kid governor of Oregon, that's what Erica is called, with us, and we made a request, and it was a very heated discussion of both sides of this issue as well as others, and that request was simply no swearing. We had a 12-year-old girl here, and no matter how people felt, there would be no swearing. And I made the comment, I just want to say this before we move on, that I don't care about scowling faces or happy faces or anything. I'm just saying that in an era of a tremendous divisiveness and tremendous polarization of issues in our state, in our community, in our nation, especially in the world, the fact that we had everyone last night and today under one roof, and being civil and demonstrating last night to one 12-year-old girl how we can have disagreement, strong disagreement, without being disagreeable, I think is imperative. And I just wanted to at least footnote that before we move forward with summary statements. Thank you.
Okay, Commissioner Farr.
Thank you, Mr. Chair. And I'm intrigued by the notion of an advisory vote, but the caveat there is that you can ignore it. I've witnessed it. It can be ignored. And I would hope that we would demonstrate the same kind of demeanor and protocol whether or not 12-year-old girls were present.
Okay, so let's now move to the summary comments of the lawyers. We have basically two more things on our work schedule this morning. One is to hear from Mr. Meek, and then Mr. Chamoff, Mr. Gary, Mr. Dingle, 3 minutes each, and then we'll have, if commissioners want to, we'll have any final board comments on today's work session. So without further ado, Mr. Meek, we'd like to invite you to go ahead and start your remarks and your timer, so please go.
Thank you. Thousands of ballot measures have been referred by state or local legislative bodies that have been ultimately found unconstitutional or preempted by law on a higher level, like state law preempting local law. But we still cannot find any instance when any liability was imposed on commissioners at any level for putting any measure on the ballot. So what you're being presented with here today is an extremely novel, basically unheard of proposition. Pointed out that there are specific cases, including those decided within the past couple of months on the federal circuit level, which is just below the Supreme Court, that it doesn't matter if a measure ends up being ruled invalid because it's unconstitutional or otherwise invalid. Placing the measure on the ballot is nevertheless a legislative act, a central legislative act that is entitled to complete immunity under the United States Constitution. And that's an immunity that the state cannot waive. In addition, find it here. So I noted earlier, preemption of the aerial spray measure has not been determined at the appellate level. The appeal of that case will proceed sometime this month, and so we would probably have a decision at the appellate level possibly within a year. I would think, however, that a measure could be passed about aerial spraying that would include within the measure a provision that its enforcement would be suspended until preemption, if it is found to be preempted, is removed either by subsequent legislation or by court decision. This is sort of similar to what occurred with Measure 47 in 2006, a campaign finance reform measure, which the Oregon Supreme Court in 2012 decided is there and will spring into effect if the court finds that limits on political contributions are consistent with the Oregon Constitution, or if the Oregon Constitution is amended to allow them. So that's another possibility. But I would say that if the folks who are asserting that county commissioners can be held liable for putting a measure on the ballot, I would ask them to provide any case that has done that. And one of those attorneys did say that liability has been imposed under 294.100. Well, let me just leave it at that. Let's find a case somewhere, anywhere, where liability has been imposed upon any local legislator for putting a measure on the ballot. I can't find one.
Okay, thank you. And I'll ask Mr. Chamoff and Mr. Gary to split your total time.
Thank you, Mr. Chair. Commissioners, one hopes that there are no cases in which commissioners have been found liable for referring measures to the ballot because when the question arose as to the propriety of doing so, those commissioners followed their attorney's advice and did not do so when there was a lack of authority to do that. Our main pitch to you is that you should be following your attorney's advice. ORS 634.057 says a county may not adopt a regulation of pesticides. That means you may not vote on a regulation of pesticides. Doing so would be without your authority and put you in the crosshairs of ORS 294-100. Thank you.
I want to thank the Commission for the opportunity to be heard. This is a matter, as you can appreciate, of great importance to my client, as well as to the proponents of the measure and to the citizens of Lane County. If I understand Mr. Meek's position, you have absolute immunity for any legislative act. That means that you could pass an ordinance today that says all of the money in Lane County's bank account shall be divided equally among the 5 county commissioners for their personal use and enjoyment, and there would be no remedy. That's just stupid. That's not the law. It has never been the law. Now, as I said earlier, it is a serious matter to disregard your own attorney's advice and to take action in the face of a threat of litigation. But that isn't the reason, not the first reason anyway, why the board should take great care in deciding to refer a measure to the voters, because doing so not only costs the commissioners and the county money, it costs the people that are proponents of the measure money, and it costs people that are opponents of the measure time and money, and it occupies the attention of the voters when there are plenty of things that will be on the ballot that should occupy their time and attention. And so I would again urge the Commission to do the right thing, not because you might get sued if you don't, but because it's the right thing. And I think it's very clear here that the measure that you're being asked to refer is a non-starter from the beginning. And for that reason, you should reject it. Thank you.
Hey, Mr. Dingle?
Very briefly, members of the board, I do want to, for folks that are watching this is a very unusual, I said it a moment ago, it is a very unusual circumstance that we would be talking about as your counsel, that I'd be talking about your potential individual liability in a public forum. It just doesn't happen very often, so I think it's a unique opportunity for the public to see how it works. And of course, it brings into focus what my job is. And my job is to protect the taxpayers of Lane County, to protect the county, and to make sure that the commission, because ultimately, if you, unless it's a 294-100, ultimately the county foots the bill. This is not a judgment on the substance of these substance of these measures. The reality is, and I know that in a shocking development, there's a disagreement among the lawyers about what the law is. There are rules and there are procedures and there are ways that things have to happen. And I certainly appreciate how frustrating it must be for the proponents of this measure to have gone out and collected these signatures and then to have this statute come up. And because as I looked, I went back and checked, there hadn't been I was trying to remember, but it had been almost 20 years since there'd been a charter amendment in Lane County. So it'd been a long time. And I can imagine their frustration when that statute was raised, the one that said that, well, now you have to check for separate vote. And then when the court concluded that that didn't happen under the way the law is written until the signatures were collected. And so you get all the way up to the end and then sort of the rug gets pulled out. I appreciate that. I understand that. But it is the law, and there is a way to change this. We've talked about it. I mean, we proposed having that examination done up front. The two statutes that are in play here, the Pesticide Act and the Forest Practices Act, certainly the legislature adopted them, the legislature can repeal them. So it's not like there isn't something that could be done, but you've got to follow the rules. And that's really what my job is.
Thank you very much. I first and foremost want to thank all of the lawyers here, Mr. Dingle, Mr. Meek, Mr. Chamoff, Mr. Gary, for all of the hard work you've put in getting ready for this work session. Took a lot of energy to write up all the materials, be familiar with it, and be able to answer the range of questions that the commissioners asked. So I really appreciate the preparation and you're all being present today with us to make these comments. And I also appreciate the commissioners for the questions you've asked and the comments you've made. I think that this has been very enlightening. I want to thank the audience. I know there's a lot of sensitivity on this issue because these advocates have been working for years to get this measure or these measures or a type of measure up for public vote. And through a series of judicial decisions, they've never received their day in court. They've never received their opportunity to get a public vote. And one of the ideas for, in some small fashion, trying to remedy that is whether or not the Board of Commissioners would ever put up a vote of some sort in response to the tremendous outpouring of support, over 30,000 people signing petitions. And that's maybe something that is outside of the scope of the today's proceedings, but it's one of the reasons we're having today's proceeding is because of that denial of what many people in Oregon think of as a fundamental right to be able to put their idea down on paper, be able to take it to the government and say, is it ready for signature, be told it is, be given the go-ahead, and then after getting all these signatures, be told, oh, no. So that's the reason why the board wanted to have this follow-up. I don't think we've had any conclusion today, other than we've had a good work session, and we've certainly learned a lot more than we did before. I just want to thank everyone, and I want to give all the commissioners an opportunity to make any closing comments they want to make. Heather, go ahead.
I'll just say something quick. As I've been researching this particular subject and all the different sides, generally take my time to process all that's been presented to me before I come to a conclusion. When it comes to the personal liability portion of this discussion, fundamentally, I think it comes down to, when it comes down specifically to 294.100, it's what our attorney, our county council has advised us. And when you then subject a board like ourselves to personal liability, like anybody else, we want to do our jobs and we want to do them well, but not at the sacrifice of our families, of our home, of the things that we built up along the way. And when it comes down to a defense of whether we have personal liability, as everybody has pointed out already, the specific advice of our county council in this case is key. And as you can tell, that gives us pause, because we do not want to sacrifice all that we've done in our lives and our families for something that possibly would go to court, be very expensive. And so what does that leave us? It feels like it leaves us, or it leaves me, with very little choice. That can be frustrating, yet that's the way the law is written. So I just wanted to at least put that out there, because that's part of what I consider when I'm deliberating what we can and cannot do up here. I do want to thank everybody for coming. I also don't think this is probably the last time we're going to be talking about this. I'm very interested in how everything plays out on the state level as well, because that will have the ultimate call on this particular subject.
Okay, any other commissioners want to be recognized? Commissioner Farr.
Thank you, Mr. Chair. You know, I too, like everybody else, would like to thank both sides of the issue. And, you know, we're getting lost in ballot measures and what is legal to put on the ballot and what's not legal to put on the ballot. And maybe sometimes we forget what the issue actually is, which is spraying. And really, you know, that's a discussion that needs to be, to continue, the pros and cons of spraying, because I'm looking at this side of the room right now, and there are people who disagree with you regarding your opinion on the safety of spraying. There are people who have studied the issue broadly who disagree with you. So there's a disagreement. So there's much discussion to be had regarding spraying. As far as putting it on the ballot is concerned, we've heard today from Mr. Weeks, who is retained by one side of the issue, and Mr. Gary and Chemoff, who are retained by the other side of the issue. And we've also heard from my attorney, our attorney, who I, thank goodness, trust. And we should trust, because we hired him and he is our employee. We should trust him. And there are a couple of things that Mr. Dingler said that really have to be considered as we move forward with any discussion regarding the legality or the propriety of placing this on the ballot, and that is ultimately the county foots the bill. That's an important consideration beyond personal liability. Ultimately, the people of Lane County foot the bill. And the second thing that Mr. Dingell asserts, and I've heard it asserted by others, is that there is a way to change the law. And the way to change the law is legislated through the Oregon State Legislature. I sat on the legislature, as did Commissioner Sorensen. We know it's a slow process, but laws can be changed through the legislature. And if ultimately we want to do something about it, then we need to look at the preemption law that's in the state legislature. Thank you.
Okay. Commissioner Bozievich.
Thank you. You know, I pondered whether I was going to attend today, I'll be honest, because I felt today, and I asked today's session be suspended after the Lincoln County decision was issued, based on some of what I brought up earlier. You know, we have 3 great attorneys presenting to us from outside, but none of those attorneys are my attorney. They don't provide me any affirmative defense if I get held personally liable for a decision I make. And yes, you can be held personally liable for a decision you make in legislative matters, because we've had a court of law do that here, and we've had commissioners settle because they didn't want to go through the appeals process. You know, I want to mention that I'm consistent about this. Recently, there was a lease agreement brought to us that had a clause in it that required some confidentiality in violation of public meetings law. I asked for that lease agreement to be renegotiated to make sure that we would not be approving an agreement that violated Oregon law. And, you know, that's just, I'll do that consistently. I will not do something sitting up here as a commissioner willfully, knowingly violating law. And I knew up front that that agreement would, so I asked for it to be changed, and ultimately it was changed. Not an easy thing to do. We were dealing with a large entity that doesn't like to change legal language, but we did, because I'm consistent about that. I will not put my personal finances, my family's personal finances on the line to do something that willfully violates Oregon law. And really, nothing in today's meeting was going to change my mind about whether or not I was going to refer something that violates state law. Knowingly do it. So, you know, this meeting's been a large, you know, almost 2 hours now of basically sitting here waiting to say I still wouldn't do it. You know, because 3 of the people speaking here today, although they're attorneys, are not my attorney. And that's really what's surprising to me, though, is just how much resource we're wasting on this. I know that our legal department's put in over 50 hours on this, and at our internal billing rate, which is hardly what I would call true legal rates, that's over $5,000. We spent basically going up beyond and doing all the, you know, processing back and forth and preparing for this. If it was external billing rates, it'd be somewhere close to $20,000, somewhere between $15,000 and $20,000 in legal costs just to get ready for this meeting. So I believe this, you know, been a large, you know, waste of our time. And it's not just about personal liability, though. What people forget was how much money the county paid in the Dumdye case. It far exceeded what the 2 commissioners paid. Go back and look if folks want to know. And what we paid their cost was matched by what we paid for attorneys internally to defend the county. So putting this on the ballot isn't just about, you know, protecting my home, because when you get named in a suit like that, it's Lane County and each commissioner individually. So I just can't see where anything we've done today would change my mind and have me go against my attorney's advice and willfully, at that point, because I'm going against his advice, that makes it willful, violate Oregon law.
Okay, any other commissioners want to make any final remarks?
That would leave me.
Commissioner Joe Burney of Springfield, Oregon.
First off, I think my personal belief is that it's imperative that we did this in public, and it's imperative we continue to. And my personal belief is it's not a waste of time to allow people, hopefully, to get closer to their day in court, especially the time and money we've spent is nothing compared to that those have spent trying to move this particular thing forward. I'm now going to speak outside of the strict discussion of laws and liability for a moment. And I do want to thank you all very much, and I mean that sincerely. And that includes you, Mr. Meeks, who I can't see, but I know you're omnipresent. When my wife and I drive up the McKenzie, we do see a lot of clear cuts, and we do see a lot of what seems like a lot of large trees depleted from that area. We as a community do. And it's not like antagonistic. We just need to educate ourselves, and we all need to ask questions. Questions like, if spraying only happens in young stands, and given the enormous amount of young stands that some timber companies are proclaiming on billboards, which is great, what is the environmental impact of so much spraying over the next 5 to 10 years? Who knows what the cumulative effects will be? Not only health, but on long-term soil and watershed impacts. I don't know. Conversely, we're not Brazil or Africa or Indonesia, where trees are not replanted to help sequester carbon. In Africa, business is burning forests and selling dead harvested wood as coal, which will be burned again, and trees will never be replanted. In Indonesia, where I've spent a good amount of time, thousands of acres of hardwood jungles and forests are burned to turn into palm plantations, and a lot of that palm is used in supposed clean energy biofuels to be burned again and never be replanted. And many of these jungle forests grow on peat, and that peat will burn for years and years. On the other hand, regarding aerial spraying here, I think part of this is it's about state law and court decisions and whether they bind our hands or not, and what is the appropriate way to move forward if one wants to change things, and where is the appropriate place to put energy. It's about power that constrains what we can do locally without incurring such liability due to state law. So I understand the community rights advocates, and I think they have a point as it relates to often private interests having an undue influence over the public agenda and public policy. I think this deserves to be at a state level, but I'm intrigued with the notion of an advisory vote. I believe that would be significant. I believe it would be significant even if this county were not allowed to move forward on implementation as a thermometer check on the public interest, the public will, the public desires, and public education, because there are multiple sides to forestry and industry management. My wife and I were recently on Kauai, restating our wedding vows. And I had an opportunity to speak to the executive director of the National Tropical Botanical Garden, who was explaining that on Kauai, sugarcane production has really ruined the soil, and at this point in time the soil is coming back, but it takes decades and decades. And he also discussed climate change in Kauai. I mean, these are the overarching issues. They aren't talking about the specific legalities of what we can and can't do. And he said what is occurring is that Kauai had 17 record-breaking heat days this last summer, and as the heat gets warmer, the mosquitoes move up in terms of the, how high they go. And as a result, the birds, the native birds that Kauai is famous for, many of them are becoming extinct. These are objective realities. So what I'm saying here is that as long as there are paths forward, which some have been articulated, that there are things within the law and within the, as it states now, that we can do some things to move forward and work on this, I think that's good. I think that we're going to get information from all the attorneys present on this notion of an advisory vote. I look forward to that. This isn't closed. I thank you for being here.
Okay, thank you very much. And at this time, I just want to say that we're going to conclude this work session. We're going to recess the Board of Commissioners for approximately 10 minutes, and we're going to go upstairs, read the executive session in upstairs. And then, so if you want to go up to the public meeting, it'll continue, but for the limited purpose of reading the executive session, we'll have an executive session upstairs. So we're in recess for 10 minutes. Thank you very much. Oh, wait. Yeah. What? Yeah. What? Are you trying to tell us something up there?
I want to meet here.
Oh, you want us to read it? Oh, you want us to read it? Okay, very good. So at this time, we will go to item number 2 on our executive session agenda, and I'll just read this briefly. Thank you for clarifying that. The Board of Commissioners will now meet in executive session to consult with counsel regarding the rights and duties of a public body with regard to current litigation or litigation likely to be filed. The executive session is held pursuant to ORS 192.660-2H, which allows the board to meet in executive session for the purposes listed above. The representatives of news media and designated staff shall be allowed to attend the executive session, but all members of the audience are asked to leave the room. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. No decision will be made in executive session, and we reserve the right to come back into public session should the need arise. At this time, we are moving up to the Commissioner Conference Room and commencing our executive session. Thank you.